Hello everyone, I'm re-recording part one here. Sorry for me. I'm talking about comparative law, comparative legal reasoning. I've just put legal reasoning on here. We will be comparing, but we're going to be comparing what people say about legal reasoning and looking at that and criticizing that. But I'm going to show you that legal reasoning really is the same. So the comparison is just going to be a process of taking, showing you rules from different jurisdictions and how they're used and understood. All right, it's easier to show you than to explain it in the abstract here. Here are the topics. I think that if this one records, we'll get down to C, finish C, and then I'll take a break and go on to part two. But we'll first talk about law, rules, norms, making law, finding law, these with some definitions. And the reason for that is that often, and not just because of translation, but often people use these words in different ways. And that causes a lot of confusion, not just to me, but to them and to other people, because, you're not comparing apples to apples, oranges to oranges and that. And then we'll look at 4 steps in making and applying the law and see that they're distinct, at least theoretically, but they influence each other. And then I'll talk briefly about the process of thinking when you're making law, the thinking processes. That first we'll talk about politicians, and then we'll ask, are judges doing something differently? Now, Normsuche means seeking the law, the search for law, the law search. And I might use that word, I like it, because there's not one in English that I know of, the search for law, law search. And it's good to think about that, because when, as lawyers, law students, judges, we are looking for the law that applies, right, the applicable law, that is a separate thinking process. How do we do that? And I threw the word systematized in there. That gets used a lot when talking about continental European law. There's a lot of stress put on that the law is systematized. It's made very important. And what happens in Germany, at least, is that you'll find most of the law in statutes, and they'll divide the law into public law, so constitutional, admin law, some other things, criminal law, which includes criminal procedure, private law, which this covers lots of things, right? Contract, tort, law of inheritance, lots of other things, and family law, blah, blah, blah. Okay. And this idea that because things are divided this way, that the Normsuche is somehow easier. Well, in the English-speaking world, we generally make a differentiation between criminal law and civil law. By civil law, we mean everything that's not criminal. So that would include public law. But then, of course, people recognize the difference between public law, and we teach it that way, right? Constitutional law, admin law. We have that differentiation too. And of course, we think in terms of separate topics like tort, contract, well, because we learn them that way. And you find books on those topics. When we're looking then for the norm, right, the rule, we're thinking in those terms. Is that, for example, in some students' tort essays, they start talking about contract law. Well, probably doesn't have any influence, might in a couple little areas. So if we're thinking contract law, as an English lawyer, we're thinking about negligence, strict liability, also a few other doctrines. We've got it systematized in our heads, and if we don't have it in our heads, we open a book on tort law. And if we're really lost, maybe we'll look at Halsbury's Laws of England. It covers all of UK law, right? And then you'll focus down. But generally, lawyers, by the time they're qualified, know where to look for the particular law, and the looking itself generally is not going straight to the statute or the rule, but looking in a book, for example, a tort book or a practice book on criminal procedure and things like that. And so the thinking process tends to be the same. The point I'm making is that the mere fact that the book that you're looking in has little signs for statute, right, doesn't make the thinking process any different, okay? The German books will be set up according to the statutory scheme, and you'll find a discussion of what this statute means, basically all case decision, collected with the statute. In California, you do the same thing. If you look in the family code or the civil code, it will have collections like that of case decisions. In England, there won't be a code on those topics, but it depends on the topic of civil law. And you'll look in a practice book, and it'll have general rules with decisions with citations to case decisions. So the process of finding the law and how you think is the same. And there's another commonality, and that is you have to have some factual situation in mind. It's like, let's say your grandpa is talking to you and is so excited that you're studying law, and says, "Hey, well, what is the law?" Right? There's bam. He said, "Gramps, so what do you mean, the law of what?" "Yeah, that's what I want to know. What? What's the law?" And you say, "Yeah, well, give me a break here. I mean, what law on what topic?" Okay, family law, traffic law, right? Contract law. What? So you have to, before you can even look for the rule, you have to have some factual pattern, factual scenario in mind. That's true everywhere in the world. Let's move on to the next slide. Now, my conclusion from studying and teaching in Germany, England, and the United States is that there's no practical difference between systematization in any of these countries. I hedged my bet a bit by saying no substantial practical difference. You notice that? No substantial practical difference. Well, I just did that because I don't want people pointing out and say, "Well, there's this little thing here." Don't give me a break. I mean, if there were a big difference between these jurisdictions, then you would have to believe that let's say German lawyers had a much easier go of it, and they would be years ahead, to be much faster than English lawyers and American lawyers. I've seen no evidence of that. And if German law is so nicely systematized that everybody can find it faster, why do you study? Why do you have to study so long? Right? I mean, it doesn't really make sense. So my conclusion is they're all systematized for purposes of the Normsuche to a basically same standard. Okay. let's not dwell on that. Let's go on to something fun. This is something that I love to lecture on and have people vote, but I can't see how you vote, so that's the sad part for me at least. But I still would like you to vote to yourself, maybe keep track, make a list of 1 to 8, and I would like you to guess or deduce which of these statements of law, these are all rules or norms, can be found in a case law and which, are found in a statute. And these are literally taken from cases and statutes, although a couple are translations, which I'll get to in a sec. Number 1, no one shall take advantage of his own wrong. That's pretty broad, isn't it? Whew. There's a common idea that statutes tend to be broader, at least a continental European idea, that statutes tend to be abstract, you say in German, right? Abstract. We say in English open-textured or very broad, right? Broadly drafted. And that's a pretty broad statute here. But unfortunately, it comes from case decisions in England of the equity courts, right? So this is one of their doctrines or norms, and it's been picked up by the California Civil Code and other civil codes in the United States by a man named Fielding who drafted them. So this is actually statute law in California. So you get 1 point. Okay, no matter how you guessed on this one. Let's go to number 2. You must not injure your neighbor. The English law students among you will recognize that as a neighbor principle from Donahue. And that's a case decision, House of Lords. Number 3. Damages shall be awarded for injury caused by the invasion of the inner realm of one's personality. Yeah, that's a translation from German. My translation, maybe not that good, but it's hard to get the idea translated. And if I have any German students out there, they will recognize this as Herrenreiter, Entscheidung. This is a case decision. Number 4, a manufacturer is strictly liable in tort when an article he places on the market proves to have a defect that causes injury to a human being. Sounds very much like the European Product Liability Directive, which uses the word producer, and the directive doesn't say strictly liable. This is actually from a case decision in California. It's California law, California Supreme Court. But it looks a lot like the Consumer Protection Act. Number 5, an employer shall compensate his employee for damage to the employee's property at the workplace. Any good guesses here? Case decision from Germany. If the marriage does not take place, each engaged person may require the other to return what the former gave as a present or as a sign of the engagement. That's a statute from California. If one sells goods twice, he who paid first shall retain them. Sounds logical, doesn't it? Like a good rule? Statute or case law? Yeah. It's a statute from Sweden. All right. I would ask you, how are you doing so far, but I can't. So let's go on to number 8. A landlord may refuse an order for a new lease if he intends to occupy the holding for the purposes of a business carried on by him. Whew. That's pretty narrow, so you might be guessing case, but it's a statute from the UK. Now, I arranged these, basically broad ones at the top, and they get narrower near the bottom, meaning the broad ones would probably apply to more situations than the narrow ones, more factual situations. You know, if you're talking with your grandfather, you might have, you know, depending what he's asking about the landlord refusing order for a new lease, right? Well, that's pretty narrow. If he's asking for something about people benefiting from other people, you could cite some broader law, like number 1 up there, okay? You can put any statutes and any ratios from case decisions on this list and come to the same conclusion. It's impossible, unless they refer to something else, it's impossible to tell by looking at these rules whether they found their source in a statute or a case decision. It's impossible, literally impossible. Now, that has some implications for how we apply these rules, but I'm going to get to that later. Okay, right now we're going to go through the next step after looking at these and ask ourselves, is there any reason why judges can't announce broad rules? No, they sometimes do, just as the legislatures sometimes do. Now, even narrower rules, which the ratios from cases, also called ratios, also called holdings, often tend to be fairly narrow, okay? But there are many, many statutes. I look at German inheritance law, in the German Civil Code, very, very detailed. And I can tell you that definitions can be found in statutes and in case decisions. Civil partners is a definition in a statute. Injury, anything resulting in death or personal injury, blah, blah, blah. This definition there I found in a case. Public figure in the United States for purposes of defamation law includes, let me see, a public official or some other person pervasively involved in public affairs. Sounds like a statute, but it's from a case decision of the United States Supreme Court. So definitions can be announced by judges, they can be announced by parliamentarians. So it's looking at this point like judges and members of parliament are doing the same thing very, very often. However, think about this, that judges announcing rules, that is not now that common. We tend to look at those rules when we're teaching law, but those are the exceptional cases. Judges will announce a new rule when they have a case that cannot be easily decided on the basis of a former rule. Very often, what they'll be doing in announcing this new rule is narrowing, rather making an exception to an existing rule, right? The kind of narrowing or giving a specification how to understand that rule in this situation. But other than that, the vast majority of the judicial activity is in finding the facts and applying the law pretty much in a way that they do all day long. And for example, in criminal cases, trying to judge, did this happen? Did this person do it? What was that person's mental state in doing that? Was it an accident? Was it intentional, etc.? Right? Things like that. And in contract cases, trying to judge what actually was the meaning of something that was said or done. How should that be interpreted? These are things that you don't find parliamentarians getting concerned with unless they're reading it in the newspaper. So, while judges are applying the law, which I have number 3 here, because we're going to look at it in this order, they're sometimes making law. Not very often. As I said, in our books that we use, textbooks, case books, we're looking at the cases where they're announcing these rules. We're not looking or announcing them or maybe applying them in certain factual situations. We're not looking at the vast majority of judicial decisions. And bear that in mind, that the judges are doing a whole lot of things that members of Parliament are not doing. And I want to get here and go on to things that that legislatures, parliaments are doing, that judges are not doing. How about empowering private persons to marry or to form a corporation or limited liability company or whatever? These are legislatively created. Okay? Judges may be called on to interpret the statutes to see were they properly formed, for example, a company, but not creating statutory scheme for people to form their own companies. And sometimes statutes will delegate rulemaking authority to a taxing authority, for example. And judges don't do that. Another thing judges don't do is raise taxes, right? Or send out armies, or for protection, or for direct the police. They're not appropriating money for disaster relief. They're not, right? There's all of these things that that members of Parliament are doing, including trying to get re-elected, that very few judges are even think about. So, when judges are forging new rules, what is their thinking process? Right? Now we're backing up. This is the first thing. There has to be a rule out there, and we're saying, how do they get created? And they get created by judges. We know that. We talked about it. But they're also by parliaments, legislatures. And what kind of reasoning are these legislators doing? For example, with disaster relief, they might be thinking about all these poor victims of flooding in York, flooding in their homes and their businesses. We should help them. It's what government should be doing. They might be feeling sorry, feeling empathy for the people. Maybe guilty because they didn't approve funding before to avoid this problem. Okay, that is a situation that isn't the judges aren't confronted with, because they don't make plans for disaster relief and that. How about this one? People sitting in parliaments deciding whether to extend to same-sex couples the benefits of marriage that are only enjoyed by heterosexual couples. What are they thinking about when they're sitting there in Parliament? They're thinking about, that's the right thing to do, but why? Well, because maybe they're doing it someplace else, but does that make it right? Because other places they're not doing that. Are they thinking, I wonder what the electorate wants? In other words, will this be popular back home? Yeah, note to self, let's ask people in my constituency. They're thinking about things like that. And maybe the fairness of excluding some couples from these benefits, and maybe other considerations. Now let's move it over to the judicial realm. Are the judges thinking anything differently? Maybe they're not thinking about getting re-elected, and for example, United States judges, federal judges, are appointed for life, literally. They're not thinking about that. Are they thinking about constituencies, what they want? Well, they're not elected. Yeah, they're thinking about what people out there, I think, but not like the particular constituency, because they're not elected from there. But don't you think in every other way they're thinking about the same things that members of parliament are thinking about? Or do you think that, no, they're thinking strictly about equality? And is this a violation of equality? Is this discrimination because they're treated differently for no substantially good reason? I don't think that's what I just said, how they reach the decision. I think that's how they justify the decision. I think the way they decide, should these benefits be extended to same-sex couples, is the same way members of parliament decide that. Right? Except there's some breaks on both of them. The parliamentarians are worried about what the constituents think, right? Can I convince them? Judges are worried about, am I violating separation of powers? Shouldn't Parliament be doing this? Those considerations are different. But the motivation for why is this a good idea or not, the motivations are the same, whether the person is a judge or a member of Parliament. Well, I think I've given you some other examples here you can read, but I don't want to take more time with these. I'd like to go on and talk about logic and legal reasoning, but this would be a good time to break, I think, because I'm supposed to keep these short. And in part 2, we'll start with this slide, logic and legal reasoning. All right?